Yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court.
Good morning. Just one quick reminder here that while we don't anticipate any technology-related problems, if we should have any, everybody just take a deep breath and we'll pause and work through it and pick back up. Mr. Hebner, if you will, please call the case.
Claudette Gilley Sanford versus Philip Howard Sanford.
We'll hear from the appellant, Mr. Horton.
Thank you, Your Honor. This is a post-divorce appeal of a grant of summary judgment. The parties were originally divorced in 2005 with an agreed marital dissolution agreement. In that agreement was paragraph 20, which stated that each party had made a full disclosure of assets. They were warranting the accuracy of the disclosure, and there would be no release from any liability if any assets were not disclosed. And the other party could make a claim if there was a non-disclosure. Mrs. Sanford in 2019 discovered for the first time when she applied for Social Security benefits that Mr. Sanford had not disclosed certain retirement benefits, approximately $700,000 in lump sum payment he received and approximately $7,000 a month in pension payments. She filed two actions. One, in the divorce case, she filed a Rule 6002 claim. She also filed a separate independent cause of action for common law fraud and breach of contract. The trial court was concerned first about...
Mr. Horton, let me interrupt you a second. Mr. Hebner, is the clock running or is it just stuck at 11:50? Thank you. I'm sorry, Mr. Horton, go ahead.
I don't see the clock, so you'll have to warn me when I reach my 12 minutes.
We will.
The court was concerned that in August of 2017, Mrs. Sanford filed a petition for contempt because under paragraph 14 of the MDA, Mr. Sanford was to provide certain medical benefits, which he did not. He was delinquent some $70,000. He was concerned that he had to pay her health insurance premiums and medical expenses until she was Medicare eligible. So he tried to settle those for $100,000. He was settling all those future and past medical claims, and an agreed order was put down, which basically said that all claims that she could assert in that case was dismissed with prejudice, including those claims in paragraph 14. Of course, in 2017, she had no knowledge of these retirement benefits. So she discovered that in 2019. She filed these two separate suits, one in a divorce case and one in independent action in 2020. The trial court dismissed all claims with a summary judgment, and the trial court stated this on page 3. Said the court may not have all the facts before it at this time. However, based on what has been presented, it looks like husband got away with fraud. However, summary judgment should be granted. All claims are hereby dismissed. The court erred in one respect on the nature of the independent cause of action. The court stated that the independent cause of action was governed by Rule 6002, and that there must be evidence of extrinsic fraud. But there's two cases that I cited in the brief, Your Honors. One is the Black case, and the other is the Moore case. The Black case, Supreme Court case, 166 SW 3rd, the Black versus Black case, 699, where those two courts recognize that in a non-disclosure case like this, where the assets were not disclosed and were concealed, you could file an independent cause of action for fraudulent concealment, separate and apart from Rule 6002. So the court first error in my view, was deciding that the independent cause of action was governed by the extrinsic fraud requirement.
What sort of relief were you seeking in the independent cause of action?
I was seeking either a monetary judgment for the amount, her share of the retirement benefits, or on a going forward basis, if he was receiving $7,000 per month, an equitable share of those monthly benefits. That's what I was seeking.
So not in the independent action, you were not seeking to set aside the decree of divorce or the property?
No, I was not. Just
Okay.
damages.
And then on the statute of limitations issue here, the 2017 action involving was it life insurance or medical insurance
Medical
payments?
benefits. That's
Yeah,
right.
medical benefits. Was there any element of that contempt proceeding that involved non-disclosure of marital assets?
No, if you look at the petition for contempt, which was attached to the affidavit of Mrs. Sanford, the petition for contempt only mentioned a couple of stocks, Chatham stock and Port Royal stock, which he provided satisfactory information about. And the third claim in the petition for contempt, he had not paid these medical insurance and medical expenses. And those were the only allegations of the petition for contempt. There was no allegation of non-disclosure. Of course, she didn't know about the retirement accounts back in 2017. The court, second error, was finding that that was an accord in satisfaction, that the language of the order stating that all claims she could have asserted under this MDA was dismissed with prejudice, and it said including the claims under paragraph 14, which only related to the medical benefits. So the court determined that that was accord in satisfaction. Of course, I cited cases that say you cannot have a release or an accord of satisfaction for unknown, undiscoverable claims. You can't release something you don't know about. So I think the court erred in both of those issues.
Mr. Hart, was he deposed and he denied any further assets, or was he just didn't report?
Well, in the affidavit of Mrs. Sanford, she attached his disclosure in the prior divorce case where he asserted that this is all I have. I represent it's accurate. And those retirement benefits are not listed. And she alleged those retirement benefits existed at the date of the divorce case. So there was no denial that these retirement benefits existed. He did not disclose them. In fact, the court's comment that it looks like the husband got away with fraud was based on the fact that that was uncontested, that he did not disclose those and they concealed those. So there's no issue about that. The court just felt that that the case was barred by 6002 because it was not extrinsic fraud, it was intrinsic fraud, and an independent cause of action for common law fraud, there is no extrinsic fraud standard that applies. It's intrinsic fraud. In other words, he made a misrepresentation about his assets, did not disclose, and you can file a common law fraud claim. The court never really even addressed, even though the court dismissed her breach of contract claim for breaching paragraph 20, the court never really addressed that in any form or fashion in its analysis. It simply dismissed all claims. And I think the court erred in that regard.
Mr. Horton, let me before you move on. But the very last part of 6002 talks about rule not limiting the power of a court to entertain an independent action to relieve a party from judgment order or to set aside a judgment for fraud upon the court.
Well, that's what the court was saying, that this was extrinsic fraud, but my common law cause of action is it was a fraudulent concealment under the contractual agreement he made with my client that I'm disclosing all assets. And the contract itself, there's case law that says a contract can survive the final decree as an independent contract, aside from final decree. You can sue for breach.
If you're correct, has it pretty much eliminated that language in Rule 6002?
I don't think so. I don't think so. If in a case like this was a fraudulent concealment of an asset, I don't think that's correct. Otherwise, the limitation of time in those rules are, I think it's 1 year.
It is.
So, I mean, if a guy concealed assets and you didn't discover it until year 2, year 5, or in this case, year 14, through no fault of your own, then as the court would say, he got away with fraud. And I don't think I think that's why the Black case and the Moore case, and also the Church case that I cited, recognize that you could have an independent cause of action aside from Rule 6002.
I'm a little mystified here how I'm sorry, Judge Capari.
No, go ahead. Go ahead.
I'm a little mystified here how these assets should go hidden for so long. If they're marital assets, why wouldn't your client have been aware that the husband here had some retirement benefits from these entities?
Well, I think that's a factual issue. If case is remanded at the factual issue on the statute of limitations under the discovery rule for contracts, it's 6 years, for fraud is 3 years. There could be some factual issues of whether it was discoverable or should have been discovered, but that's a factual issue on the discovery rule, I think, Your Honor, whether she should or should not have known. She says she didn't find out until she applied for Social Security benefits, and Social Security told her, by the way, your husband had these retirement benefits with Coca-Cola and Coca-Cola and Crystal, which she said I did not learn about until I applied for Social Security.
Mr. Horton, what did he actually purchase with the $100,000? What was that for?
He was settling a claim that he owed $70,000 for past medical premiums and medical expenses of Mrs. Sanford. She had pre-existing conditions when they divorced, and he agreed to pay for her health insurance premiums and pay for uncovered medicals. He had not done that. And this obligation continued until she was Medicare eligible. So he wanted to buy himself off. He wanted to buy those obligations off. He did not want to have those obligations. So he paid $100,000 for the back benefits and the rest for the future benefits. That's what the $100,000 was for.
What is the meaning of all claims has or could have had against the husband pursuant to the MDA?
I think you have to read the end of that, including claims under paragraph 14. Again, the question of what were the claims that could have been asserted at that time under the MDA, and the only claims that arose by reason of her petition were these 2 stocks, which was resolved in this medical claim. So she didn't know about the retirement benefits, so she couldn't have resolved issues regarding retirement benefits of which she had no knowledge. And the court construed that language very broadly, obviously. And I argue it should be construed narrowly in relationship to the actual petition and what was before the court at that time.
All right, counsel, you have your time for rebuttal. We'll hear from the appellee.
May it please the court, Lawson Kamalinka on behalf of Philip Sanford, who I'll refer to as husband throughout. And I just want to note from the outset, because this touches on a number of the questions that y'all raised and that are being presented to the court. So the allegations that wife is attempting to make in her amended complaint involve financial assets or information about the assets that she didn't receive prior to the divorce being finalized. Obviously, I wasn't there as negotiating with Mr. Horton. I wasn't even in law school at that time. But the husband was represented by Roger Dixon, who I'm sure the panel is well aware is a very upstanding member of the bar and who's well known and respected for his integrity. And so I don't think there's been any kind of hint of a suggestion that there was any impropriety on his part. And if you look at the record itself, there's really no indication that this was an active deceit, an active hiding of these assets. What's logically what this likely is an accidental omission of the assets. And that makes sense that this would be an accidental omission. This is not something that husband would think he could get away with hiding. This is not, something he could secret in a corner or bury a gold bar in the backyard or something.
Well, Mr. Convalinka, doesn't that go to whether or not the plaintiff can prove her fraud claim, whether it was intentional or just an accident? I mean, doesn't that really go to whether or not?
I think it does, but my point is, and I'll get there. My point is that this is what the assets are retirement benefits of one of the large, for executives, one of the largest companies in the world, and that this is really a Google search away from discovering that these exist. And my point is that wife could have, with a minimal effort of due diligence, discovered the existence of these assets.
But I'm concerned, I mean, it's what you seem, I mean, it strikes me that this is probably a good statute of limitations argument case here, but it seems like to me that those facts need to be developed, that we can't just jump in and take away from the court the statute of limitation defense here.
But what many of the cases on a number of the different arguments talk about is whether the facts are inherently undiscoverable or not. And this is not the type of evidence that is inherently undiscoverable. Rather, this is, the reason that, discovery exists is to get complete and accurate information. And to be fair to wife, in this situation, wife did, it looks like from the record, request interrogatories and request for production. However, what's equally clear from the record is that wife, and this is in her own representations in her filings in court, is that she said, in lieu of doing formal discovery, in lieu of doing depositions, she decided to accept husband's presentation of a balance sheet. And we actually have the balance sheet in the record. If y'all want to look at it, it's on page 155. You'll notice when you do look at it, it's not extremely detailed. This is a one-page sheet. It is, it's not sworn. It doesn't have earmarks of formality. These are certainly not documents from the financial institutions themselves. What this is during divorce negotiation, husband says, this is my understanding of what my assets are. And wife chose to accept that. She chose not to do further discovery. She chose not to do the due diligence that would have revealed these assets. And I just think that is worth remarking on, because the lack of due diligence on wife's part does color and affect a number of these arguments. So saying that, I'll go to the arguments themselves, and I'll try to address them in the same order that Mr. Horton presented them. Knowing that there's no presumption of correctness of the trial court's order, in looking at the memorandum order, it is correct. It is logical. It follows Tennessee law, and particularly, it's 100% right that this is, despite the framing of wife, that this is a common law fraud action. This is in fact an action pursuant to 60.02. And the court recognizes that. And both a husband and wife have relied on the 2005 Supreme Court decision, Black v. Black, which Mr. Horton mentioned earlier, in support of their positions. And husband embraces that and says, absolutely do look to Black. I think it is a case that's on point. The facts are very similar to the facts of the instant case. And I think both sides have developed their arguments well in their briefing with regard to that. What I wanted to take the opportunity right now to do, though, is what our brief did not do is talk about the Black case in the sense that the 2005 Supreme Court case was a case that affirmed this court's decision in 2004, Black v. Black. And in looking at this court's decision, not that there's any inconsistency with the Supreme Court, but it is illuminating because, for one, it's longer. And where the legal analysis is pretty much the exact same as the Supreme Court's, what this court's decision does is delve deeper into the facts and does a really good side-by-side comparison of other cases, some that Mr. Horton mentioned, like Moore v. Moore. And so the case distinguishes Moore v. Black, then also distinguishes Tanner v. Tanner, but then looks and says, what's a case that's more analogous? And it's Shore v. Shore. And Husband would submit that both Black and Shore should control in this instant. There's a lot of similarities. As Mr. Horton said, he's not, for lack of a better term, he's abandoning a 60.02 argument. He's not trying, he's saying that the trial court got that wrong and that really it's not an extrinsic fraud analysis. He's trying to convince you that the wife's allegations in her amended complaint are a standalone common law fraud case. Those same facts exist in Black and Shore. And those cases, they're both divorce cases, and the wife in both those cases is the plaintiff, and she alleges that husband has misrepresented or withheld assets from the marital state, and induced by fraud her to sign the NDA. So extremely similar, right on point. In both those situations, the appellate court says, while wife has framed this as a common law fraud action, this is really a 60.02 action. And how we decide that is we look at the allegations, we look what's being alleged, and we look for the relief that's being requested. And so that question was asked and by Mr. Horton, what relief is being sought? Well, first of all, wife is saying, in Black, as in this case, while we signed the MDA that said there was no fraud in this case, we want to modify that part of the divorce decree, because actually we do think now.
Counsel, let me ask you about that. When the parties say there's no fraud in that case, are they simply saying that they haven't committed any fraud, or are they saying I haven't committed any fraud and neither has my spouse?
Well, I think it is the issue of it's been litigated. We've decided through this litigation process that this is not the result of fraud. And so we want this contract to be upheld.
All right, but in the MDA where it says there's no fraud, the party can't really be representing, or can they be representing that the other party hasn't committed fraud? I think in a sense, yes. And probably more accurately, what they're saying is the process they believe is free from fraud, that they think that they have done enough of their homework to determine that this is free from fraud, this contract's free from fraud, which is relevant to later issues and res judicata issues. But
so seems like the trial judge stood on the proposition that there was an accord and satisfaction. If there is a fraud, can there be an accord and satisfaction?
So what the trial court said was there is an accord and satisfaction. That's absolutely right. The trial court actually had two findings. The first finding was this is actually a 60.02 action. And so for a fraud claim to survive, it has to be extrinsic fraud. And then the second finding that the trial court had was there is an accord and satisfaction. And what husband would submit is that if the fraud was discoverable, if it was known or knowable, then that accord and satisfaction would survive. And so it's not so much the fraud aspect, it is what knowledge do the parties have the ability to know, if I answer your question.
Yeah, go ahead.
Okay, and so what I wanted to point on, just one last thing on the 6002 designation rather than the common law fraud is, if you look at wife's allegations in her amended complaint on paragraphs 11 and 12, she's not even bashful about it. She is trying to amend the divorce action. She is asking for relief within the divorce action. And so there is really no way to view this as an attempt to modify or alter the divorce decree, the finality of the divorce decree. So that's for those reasons, we would submit that it is properly considered a 6002 action. Now, with regard to the accord and satisfaction that Judge McClarty was asking about, and I think a number of you asked about, Mr. Horton said that the language that was agreed to was included the attorney's fees and medical fees and the securities. What he neglected to mention was the rest of that clause. It's including but not limited to. And so what the wife is basically asking this court to do is say, while we have this language and we agreed to this language, and from the record, it looks like it was wife's counsel that actually drafted the language. Mr. Horton may be able to correct that if I'm wrong, but that this language that says all claims that wife could have made or has made, including but not limited to, she's saying what we really meant by that was it's not including but not limited to, it's limited to. And it's not all claims that we could have made, it's all claims that we have made. And so only if this language has no meaning can that argument prevail. And I don't mean to be glib about that, but it is directly contrary. Her position is directly contrary to the language that is in the agreement in that 2017 settlement. Wife will be raising her hand saying, but I didn't know about that retirement, the retirement accounts. I didn't know about that. So this accord and satisfaction shouldn't count. But that's what I was trying to, my initial point that covers so many of these arguments is she may not have known, but just because she did not know does not mean that she could not know. And the law regarding the accord and satisfaction is whether this is knowable. And it's not really in dispute that if wife had done the due diligence, these assets would have been uncovered.
Why? I mean, you say it's not in dispute. Husband listed his assets and he chose not to list this. Why would we, are you asking us to assume that, well, if you'd asked him an interrogatory, then he would have come clean?
Right. and maybe the not in dispute was inartful. What I'll say is that he may have neglected to list it. He may have chosen to list it. We can't know that, right? It was not listed. But what it could have been found via formal discovery, we assume, or independent investigation. Again, this is a public company that puts out what their executive retirement benefits are. So through an independent inquiry, I do believe that it is correct. She could have discovered this.
Okay. Thank you, counsel. We'll hear from the appellant rebuttal.
To remove any doubt about what I was doing here, Your Honor, I did file two separate actions. One was a Rule 60 motion in a divorce case. Then I filed a separate action with an independent case number for common law fraud and breach of contract. And those two actions were consolidated. So it was not a single action under the final divorce decree. And since Roger Dixon's name was invoked, I want to make it clear that I'm not accusing Roger, a friend of 50 years who was also in my wedding 45 years ago, of any fraud. At 1:53, Roger simply sent me a letter saying encloses the balance sheet. Okay, and the balance sheet does list some Crystal stock and Coca-Cola stock, but it's not list retirement accounts. And I think if it was unintentional by Mr. Sanford, the fact may show that. I just forgot, all right? And I didn't realize I needed to add my retirement accounts. There is a breach of contract claim because
Mr. Horton, did Mr. Dixon, he represented the husband in the initial divorce case, is that right?
That's correct. Roger
Okay.
represented Mr. Sanford.
All
So if it was unintentional, Mr. Sanford, Roger, here's the balance sheet of all the assets I have. And he said, he hasn't been deposed in this case. He said, I just forgot, or I didn't realize I should list those. Then there is, under paragraph 20, he does warrant that it's accurate, includes all of his assets. So there would be clearly a breach of contract claim, which the court never addressed in this summary judgment order. The court just dismissed all claims. Thank you for your time this morning.
Of course, thanks to counsel for both sides. We appreciate your briefs and your oral arguments. You certainly, I believe you've made your client's positions clear on the issues. Mr. Hiven, if you would, please recess until 11:30.
This honorable court is now in recess until 11:30 a.m.
Thank you, lawyers.